Chapter 3. Administrative Tribunals. In 2024, I co-edited a book entitled Administrative Tribunals in the Common Law World, which brought together some of the leading scholars in this field. As we said in our introduction to the book, it is indeed a paradox of such a major international collaboration on tribunals that this book cannot, or will not, produce a global definition of a tribunal, though that difficulty has only been confirmed and compounded by the many experienced contributors to this volume. Examples from the book were Hugh Corder's statement that tribunals in South Africa take many forms, function in a myriad ways, and have radically varying levels of workload, efficiency, and effectiveness. Guy Seedman's statement that the definition of what constitutes a tribunal is vague, as is the precise number of entities that currently operate as tribunals in Israel, and my own conclusion that my initial attempt to come up with a definitive list of tribunals in Hong Kong was futile. The fact is that it is much more difficult to offer a concise definition of a tribunal than many other institutions of administrative law. It is often said that tribunals look and operate like courts, but fundamentally they are not courts. Tribunals are usually more specialized than courts, in the sense that they tend to be set up to deal with disputes in particular areas, for example, specialist immigration, taxation, or housing tribunals. They are fora in which individuals affected by government decisions can challenge them by way of appeal. The tribunal will often have the power to confirm the original decision, for example, a deportation order or the rejection of an application for public housing, or to change the decision. The instinctive response may be that this sounds like the work of a court, but that would be wrong. The reason for this is subtle but vitally important. Courts consider issues of legality, nothing more. They are, after all, courts of law. If a person challenges a government decision in a court, they can only win the case if they prove that the government's decision was unlawful. If their complaint relates to anything else, for example, whether the decision was inefficient, foolish, or hypocritical, the court cannot consider the application because these are, usually, not matters of law. We describe these as relating to the merits of the case. Courts cannot consider the merits of government decisions because the constitutional separation of powers rule tells us that while courts decide legal disputes, they cannot decide matters of policy because that is for the executive branch, in other words, the government. This principle was famously espoused by the French philosopher Montesquieu, but also finds earlier expressions in the works of Aristotle, John Calvin, and John Locke. In administrative law, this distinction between the legality and merits of a decision is vitally important, though in some legal systems the distinction is blurred.